But so for some of you who might know some of the work that I'm engaged with, it is often involves a triangulation between ethics, what some people might call critical legal studies, so engagement with legal questions. And that particular set of interests, which has been so important to my work, had to engage with computational modes of governance, but also computational modes of thought, precisely because of the ways in which algorithms are become a very kind of significant force within military operations, within predictive policing, etc. And in particular, my interest has been in relationship to the kind of ethical questions that automated decision making kind of raise. So this is in some way where the work was situated. Today I want to make a bit of a shift, so I need to set out a little bit of context before I try and make the kind of specific arguments. So we're actually going to be very much in an analogic world for quite some time. So I hope you'll bear with me, and I also need to read to keep my self focused. So I think I will just begin. So in this presentation, I wish to explore the emergence of two distinct institutional mechanisms that were established during the latter half of the 20th century, each of which has responded to the injustices of war and state violence in ways that are suggestively computational. In particular, I consider how a certain algorithmicity and programmability that lies at the heart of law can prove useful for reflecting upon the operations of these institutions in their quest for truth and justice. The International Criminal Tribunal, with its elaborated rules of procedure and evidence, has, I argue, transformed the juridical apparatus into a quasi-machinic set of operations that compress the effective realm of experience through the legal strictures of testimony and cross-examination. Adjudication over what might be counted as evidence or who may be called as a witness requires that the expressive qualities of material evidence and the performative dimensions of speech are subordinate to the production of fact. Whereas the Truth and Reconciliation Commission, or TRC as I'll continue to call it, which has no legal mandate but is in general organized by a quest for justice and ethical demand that the perpetrator of violence account for and admit to wrongdoing, could be characterized by way of contrast as a kind of incomputable object, one that operates in excess of calculation. The incomputable thus designates an incommensurate mode of expression or entity which can't be fully apprehended and made subject to various modes of governance and control. Within the South African context, the TRC, which conducted hearings from 1996 to 2000, had the power to grant amnesty in exchange for frank testimony. The distressing and oftentimes diverse forms of exchange between victims of apartheid and its perpetrators, which included detailed reenactments of torture, was not circumscribed by legal conventions that would submit such painful forms of testimony to relentless forms of cross-examination. In Canada, the objective of the TRC was focused upon listening to stories recounted by survivors of the residential school system, in which more than 150,000 children were forcibly removed from their families and communities, with upwards of 6,000 of them dying. Over the 6 years of the Commission in Canada, which ran from 2009 to 15, more than 7,000 witnesses testified to their physical and sexual abuse, malnourishment, and ill-treatment in the schools, the last of which only closed very recently in 1996. On June 2, 2015, the TRC found that the Canadian government had committed cultural genocide, of which the establishment and operation of residential schools was a central element of this policy. Throughout the Commission's work, I'm just going to go a little bit ahead here. Throughout the Commission's work, they encouraged the performance and integration of cultural rituals, such as Aboriginal drumming and song, as part of its mode of public address and reckoning. In contrast to these more performative methods, a 1986 legal dispute over Aboriginal title or native land claims between the Dilgamuk First Nations and the Crown in British Columbia, which is where I'm from, was denied on the basis that oral traditions could not stand on their own as historical evidence over land seizure. As the trial progressed, presiding judge, Chief Justice Alan McEachran, became increasingly impatient about having to actually listen to the oral histories from the Gitsen plaintiffs. The judge asked whether it would not be sufficient to have the words written down, as their storytelling mode of address would most likely get him, the judge, not much nearer to the truth that he sought. During the trial stage of the dispute, Mary Johnson, who was also a chief, just going to stop there. Pardon me. Mary Johnson, who was also a chief, was asked to sing her song of mourning, which is a crucial feature in determining the legitimacy of territorial ownership within First Nations culture. This disruption to courtroom rituals of presentation irritated Justice McEachran, who took exception, particularly to witnesses singing in court. This is a trial, he reproached, not a performance. Besides, he added, the significance of the music was lost on him as he had a tin ear, so it's not going to do very much good to me to sing to me, he said. While the Supreme Court of Canada would eventually go on to accept oral traditions as an expressive form of testimony and evidence in their own right, the performance of a song in which land ownership was encoded during the provincial trial was subject to both narrow legal definition of what constitutes evidence, as well as a judiciary who is ontologically incapable of opening his ear to that of the other. Through its public performance, the song might be said to have produced a legal rupture and even a surfeit of information, an acoustic resonance and effective remainder that reverberated within the body of the witness as well as that throughout the trial chamber. Unlike the rule-based logic that organizes the criminal tribunal to arrive at a verdict, guilty or not guilty, upon an evaluation of all tendered evidence and testimony, the effective processes of the Truth Commission can't be fully captured by an instrumental or computational conception of justice as merely on or off, right or wrong, empirical fact or ontological fiction. And I just want to quickly play a little example from the Icty, International Criminal Tribunal for the former Yugoslavia, in which we have a cross-examination between Slobodan Milosevic, former Serbian president, and Larry Loshia, witness, just to give you a sense of the kind of difference between these two kind of institutional forums.
Is filmed and every single body is identified.
Yes, we're going to look at all that very carefully. Don't you worry about that, and experts will take a look at that too. Never you mind. But what I would like you to tell me is how, by showing the picture of a body in a meadow, set out to prove that death was caused by execution. And then you go a step further and say that death occurred through execution, and that the execution was carried out by the Serb army and police. How do you prove that by showing the picture of a dead body, of a dead man in a meadow?
So when the rule of law is violated, can the injustices of political violence be met by the protocols of the court? Or do they require the production of new ethical arrangements in which contingency rather than predictability is its defining feature? A condition of indeterminacy that I feel is widely accepted within the operations of the Truth and Reconciliation Commission, but is governed by a strict legal calculus beyond reasonable doubt within criminal law. Can theoretical frameworks borrowed from software studies and structural logics derived from computer science provide new tools for analyzing how these forms organize themselves and articulate their particular modes of practice? How might knowledges and methods borrowed from other disciplinary domains open up alternative conceptual pathways into existing problems and questions? Now, emphasizing an apparent continuity between the law and its computability is not simply to attribute a formal or mathematical logic to its functions, but is also a philosophical latency and historical inheritance. Indeed, the very origins of certain legal processes inform the language of computation, such that the term execute, as in to execute a coding script, heralds from the 14th century legal reference to carry out or accomplish a course of action, to prosecute, to issue a warrant, or to sentence. With the advent of electronic programmable computers in the 1940s and their capacity to store, index, and retrieve data, possibilities for quantifying and systematizing legal processes arose. Interest in automation was already growing across a wide range of sectors as the influence of Claude Shannon's mathematical theory of information was combined with Norbert Wiener's wartime research into cybernetic feedback loops and communication control systems. Given the data-intensive practices of trial proceedings and their reliance upon previous legal decisions or precedents, it is perhaps not surprising that efforts to apply scientific methods to law would take hold during this time. Quote, jurimetrics, as the new field was aptly named, gave legal practitioners much greater access to case law, which in turn facilitated the planning and building of cases and led to the standardization of legal terminology. Jurimetrics is concerned with such matters as quantitative analysis of judicial behavior, the application of communication and information theory to legal expression, the use of mathematical logic in law, the retrieval of legal data by electronic and mechanical means, and the formulation of a calculus of legal predictability. So I'll leave this slide here just in the background. So today, this rather marginal field, jurimetrics, has evolved into what is now referred to as legal computing or computational law, and is predominantly concerned with the modeling and analysis of big legal data and with the automation of certain legal conditions within online domains. For example, all transcripts of ICTY proceedings are fully searchable and indexable using key terms and filters. Now, given the more than 9.3 million archival holdings of the ICTY, the ability to manage its legal data is essential, as no prosecutor or defense team could ever grasp the entirety of a multi-year case with innumerable branches reaching into other prosecutions and appeals. The Creative Commons attribution is another example of a computational legal instrument in which customized copyright licenses are generated for online content. These tools allow legal data, so regulations, rules, contracts, to be exchanged quickly and easily within electronically mediated environments and are commonplace, even if we are not fully aware of such legal functionality when browsing. The nascent area of algorithmic law is yet another evolution in efforts to apply automation to legal decision-making. There have also been many attempts to create a machine-readable or machine-executable legal code. A machine-readable code would simplify the analysis of legal code, allowing the rapid construction and analysis of databases without the need for advanced text processing techniques. A executable format would allow the specifics of a case to be input and would return the decision based on the case. So, algorithmic law allows legal practitioners to actually model cases in advance, both things like jury selection, the kinds of witnesses, the kinds of evidence that would bring in. So here we have a certain kind of legal arrangement that is being used in the same way that parametric design would be used in, say, the field of architecture, to run different kind of scenarios and see what kinds of legal outcomes they might actually produce. In my 2014 essay, which was mentioned earlier, Deadly Algorithms, I asked how legal codes could preside over the proposed use of automated decision-making within the US-led war on terror and its reliance upon armed combat drones to kill suspected enemy combatants without recourse to due process, that is to say, a full and fair trial. Therein, the term execute had a triple meaning insofar as only the only the American president can execute the kill order by executive decision, which in turn is executed by a coding script that operates the remote control drone that is itself engaged in acts of summary execution. Given the increasing oversight of algorithms to situations of questionable legal conduct, such as anti-terror operations or predictive policing, the use of algorithms as a management tool for the legal industry seems one of logical symmetry. Here's a quote from a barrister. The practice of law is not immune to the algorithmic future, and legal service delivery will not be insulated from the world of computers. Lawyers and law organizations that want to survive the restructuring of the industry must become adept at understanding and using technology, including algorithms, to deliver what clients want in legal services. As I've tried to suggest, the relationship between law and computation already has quite an extended, even if at times unacknowledged, history of mutual involvement, albeit one largely organized around efficiency and automation. Yet, how can the law respond to the advent of algorithmic culture while remaining indifferent to its broader social and cultural transformations? What I'm proposing in this short presentation is perhaps much closer to the argument that the lawyer and media theorist Richard Sherwin forwards when he inquires into how visual and screen-based media are actively changing the ways in which the legal mind thinks. A shift in emphasis from media, or in my case, computation as a tool for use in delivering law, to a fundamental force in reorganizing the ways in which jurists conceptualize and understand the world. Likewise, philosopher Luciana Perezi, who's a colleague of mine at Goldsmiths, she has made the provocative statement that algorithms do not simply govern the procedural logic of computers, but more generally, they have become the objects of a new programming culture. In her discussion of software space, Luciana goes on to ask whether it is possible to define algorithms as objects whose ontology is not strictly limited or strictly determined by mathematics or physics. Quote, the ontological claim for an ultimate merging between information and matter does not seem to account for a simple but entirely inevitable question, namely, how can that which is abstract remain as real as that which is concrete, end quote. Now I realize that Parisi is arguing for an understanding of algorithms as a form of actuality in their own right and not simply as a set of instructions for bringing about a set of external operations. For my part, however, I think in addition to exploring computation as inaugurating a new mode of legal thought, I still wish to hold on to a certain notion of analogic technicity, which might be considered somewhat mechanistic, and even deterministic rather than generative, as is the case with distributed computing. At least that seems to be sort of my observation in the ways in which I am looking at certain kind of legal instruments. Now, I do believe that this is useful for observing the machinery of the law in action, especially as concerns tribunals, the specific context of my analysis. Everyday characterizations of the law as legal instruments have long served to emphasize a technological vernacular at the core of its operations. While metaphors drawn from the humanities are widely used in computer science and software development to help naturalize the novelty of computational objects by locating them within the grammar of existing milieus, neither is this what I'm proposing in considering the computability or indeed incomputability of entities such as institutional forums for adjudicating over the aftermath of political, state, and colonial violence. Here's a quote from Colburn and Shute. Computer users have incorporated files, directories, folders, directories, files, registries, and pages into their language. Operating systems run servers, clients, and daemons. Application programs execute threads, occasionally experience memory leaks, and undergo garbage collection. Program exceptions are thrown and caught. Programmers organizing data regularly speak of stacks, queues, trees, pipes, and streams. Tribunals and truth commissions are more than simply metaphoric expressions of computational-like processes, but are themselves consequences of new modes of thinking and acting. If metaphors within computer science, such as Colburn and Schutt, contend, are used to name an abstraction that manages complexity, the metaphors or analogies too must be rethought as more than simply devices for mediating innovation through recourse to established ideas, but as operational. Metaphors do necessary work. The abstractions of the law are often mediated by the rhetorical device of analogy to help communicate complex ideas. The analogous situation is not just a handy rhetorical tool, it is a mechanism of mind, a way that we cognitively process our experience. The analogies embodied in metaphoric language provide not just a logical experience, but a sensory one as well. In other words, jurors are able to both understand and get a feel for your argument through analogy. As Brian Masumi has likewise suggested, when one poaches a concept, a certain residue always carries over from one domain into another, its affects. And this is what can be repotentialized through acts of critical borrowing. Using conceptual frameworks derived from computation in order to reflect upon the practices of tribunals and truth commissions offers another means by which law may enter into a productive relay with media and information theory to develop alternate analytic tools and produce new theoretical and political insights. Manipulating theories and ideas, not only at the level of metaphor, but also at the level of their coding, requires acts of strategic piracy if such adaptations are to find their relevance within other spheres of activity. In his book, Visualizing Law in the Age of the Digital Baroque, Sherwin stresses the need for the production of a new legal imagination that can better account for the myriad of ways in which visuality, especially as constituted by its digital forms and formats, actively constructs legal realities. Here's a quote by Richard. Jurists need to cultivate a new visual literacy so that they may understand better how images work, the better to cultivate competencies in visual communication, cross-examination, and judgment, end quote. A cursory look at any number of contemporary legal proceedings would quickly reveal the degree to which media has transformed the ways in which legal questions are being pursued and presented, both in and outside of the courtroom, as well as the ways in which its juridical infrastructures are being designed and managed. Despite the reliance of legal practices upon all manner of technical media, the degree to which they are seen as hacking into and even altering its actual source code, its legal logic, seems to go largely unnoticed. From pretrial interviews, press and websites for discussing information related to upcoming cases, evidential materials, visual aids in the form of animations and digital reenactments that assist with witness recall or help lawyers narrate a complex sequence of events, reports of experts reliant upon specialized software and hardware for conducting their analytics, to the actual documentation of trials, which enable the potential review of proceedings during appeals and retrials, not to mention the media delivery systems that organize the court from microphones, translation booths, cameras, to computer screens for the presentation of exhibits and records. Considered altogether, it is perhaps astonishing to realize, as Sherwin notes, just how little attention has been paid to the ways in which media are actively transforming the ways in which the legal mind thinks and does its work. Sure, these digital tools are handy, said one ICTY prosecutor to me in The Hague, but a court case was like a journey. As long as one arrives at one's destination, it doesn't matter if by car or bicycle, he said. The outcome of the trial is what matters. And the technical means or methods merely function in the service of that objective, which in his case was to prosecute and convict war criminals. Now, while I understand the point he was making, namely that it was his job to work his way through all the materials and situations presented in order to arrive at the truth of what had transpired, regardless of the challenges encountered along the way. If questions arose as to the veracity of a video documenting an atrocity, then it was his legal task to ascertain its probative value through witness testimony, cross-examination, and forensic testing. The facticity of any given media artifact, he maintained, was arrived at through strict compliance with the rules of procedure and evidence that governed the proceedings of the tribunal. Media exhibits were, in this instance, no different than any other form of evidence, and the fact of their emergence at the scene of the crime in the form of amateur camcorder footage, for example, or later in the court as exhibits, were not to be deemed particularly noteworthy. Yet, we know that the widespread availability of video functionality on mobile phones and smartphones has arguably changed the ways in which policing is being conducted and opened up new channels for civic participation in the demand for accountability. Media matters, not just in terms of providing novel tools and new forms of social and cultural organization, but as a mode of thinking and cognition itself. An insight that is perhaps not strictly speaking useful for a lawyer prosecuting a war criminal, but which may prove valuable for engaging in meta-reflections upon the institutions in which such practices actually take place. How am I doing for time? Okay, sorry. I have an example from early cinema that I think is useful to talk about the emergence of this new legal mind that I'm trying to argue has to take into the account the emergence of a new set of legal modes of thinking that are actually start to emerge out of the kind of computational algorithmic domain. So the example I want to draw on comes from the early days of cinema, in which shots were arranged in temporally contiguous relationships to achieve narrative coherence. Now, in the, say, 30s and 40s in cinema, many more close-ups were required to explain how characters moved around in time and space. A hand turning a doorknob was needed to indicate someone's passage from an anteroom into an interior office. A straight cut or edit between these two distinct spaces could not be sutured by the viewer's cinematic imagination. Yet today, our seemingly effortless capacity to generate narrative cohesion between multiple temporalities and distinct spatialities has emerged out of considerable visual training over many decades. Fast-paced editing and delirious compositing, facilitated by technological changes, have in effect produced a new cinematic brain, fully able to think images and sounds differently, and thus also to comprehend their specific relevance. I think this is an important moment to reflect upon, and is not quite the same as suggesting that media have simply changed the ways in which we process and manage information, or the ways in which it structures and determines our interactions. To a large degree, this is also the primary challenge that Sherwin takes up when he asks, how does visual culture alter the legal mind, and with what consequences for the practices and theory of law? I would like to redraft this question to inquire into the ways in which computation itself might be considered an agent in the transformation of legal attitudes, even if I will not be able to explore this within the confines of this presentation. As an artist and a writer, I'm obviously not engaged in analyzing the same things that are studied by lawyers, but I have a keen interest in studying and analyzing the practices of such forums, such as the ICTY and the TRC, which assume an instrumental stance towards justice in the former and a more activist bearing in the latter. As philosopher of science Isabel Stengers has always insisted, science does not belong to the domain of the scientist alone, nor by extension should an interest in legal processes remain exclusively to the jurisdiction of law, nor computing to practitioners of computer science. We need rather to be attuned to the ways in which different systems are already mutually effective. In the polemical essay, Decolonization is Not a Metaphor, its authors, Tuck and Yang, critique the widespread assignation of the term decolonization to all manner of projects, political and otherwise, especially within contexts of settler colonialism. Instead, decolonization, they insist, needs to be understood first and foremost as the unequivocal repatriation of indigenous land and life in the Americas. In laying out their forceful argument, they posit an ethics of incommensurability that recognizes what is distinct and what is sovereign for projects of decolonization in relation to human and civil rights-based social justice projects. By this, they mean that opportunities for solidarity lie in what is incommensurable rather than what is common across these efforts. Now, I wonder whether forums such as the TRC of Canada might offer context for conceptualizing an ethics of the incomputable, the irreducible, and the incommensurate, not as an easy path towards reconciliation in which historical wrongs are righted so that we can move on, but as a complex process of speaking to history and listening to the stories that had previously fallen upon deaf ears or were willfully ignored or violently suppressed. Testimony is given not in order to met out punishment or acquire compensation, but as a public claim for recognition of that which took place, whether events occurred during the more recent decades of political repression or over extended periods of colonial rule. Testimony is given so that the survivors of historical injustice can begin to live in the present rather than to merely endure. Testimony is given so that the conditions for a shared humanity might eventually begin to be assembled out of radical difference. Can entities such as Truth and Reconciliation Commissions, in contradistinction to the formal legal mechanisms of international law, unsettle legal bias and decenter their privileged vantage point from the juridical bench? Luciana Parisi argues that Luciana has argued that the behavior and ontology of algorithmic objects, which arises with interactive and distributive computing, needs to be understood as generative, not simply defined by a finite set of rules. Only when computational thinking is grasped in this manner does it offer a conceptual framework whereby the formal rules and coding practices that script our institutional responses to state and colonial violence could give way to the emergence of new ethical arrangements and political imaginaries. One generates rights, not through inheritance or conviction, or even by way of recourse to transcendent declarations of universality, but by one's actions. For Gilles Deleuze, reflecting upon the French legal tradition, jurisprudence doesn't refer to the study of the underlying principles of law, its legal source code, but concerns the creation of new laws as well as the creation of rights expressed by and through these laws. Jurisprudence, he argued, is everything that creates problems for the law, that threatens to call what is established by law into question. Jurisprudence was thus conceived as a domain of thought and practice that was productive of rights, a way of acting and being acted towards, and therefore was also productive of new forms of political life. I'm just wrapping up here, my final paragraph. With Deleuze's legal provocation in mind, could the search for justice that impels the activities of a Truth and Reconciliation Commission also be theorized as conceptually aligned with a much more radicalized understanding of the algorithmic realm as generative of new data configurations, fully capable of evolving new modes of behavior? While the horizon of computation for ethical decision-making includes the possibility that the most mathematically principled result may involve one's own sacrificial demise, an ethics derived solely out of mathematical axioms and calculation is untenable, whereas one that is incomputable, that is to say, the consequence of generative models of novel interaction between subjects and their contexts, holds out considerably more promise. Of course, every practice creates its own particular forms of intelligibility, which determine its specific attachments and combine to assert its relevance. The particular value of a song or native drumming or the reenactment of a crime across differently constituted domains of practice may resist remediation into pre-established formats, producing instead frictions and incommensurabilities that challenge accepted norms. Although the consequences of state and colonial violence would not change, conceptions of justice could assume a more projective and holistic character than those produced by judicial mechanisms figured around sentencing and arrived at through the retrospective application of law. The search for truth as an experimental form that emerges out of an algorithmic-like set of practices in which indeterminacy, contingency, and incommensurability are its operative modalities must prevail over the reductive logic of systems and institutions that will only ever return predictable search results. And I'm going to leave it there. Thank you very much.